Welcome to the lesson on countermeasures in international law. As usual, the learning materials for this topic can be found in the description below the video in order of appearance. Dennis Alland defines countermeasures as responses by a state to an internationally wrongful act committed against it. Although such acts are not lawful in the strict sense, international law treats them as justified under certain circumstances because they aim to induce the responsible state to comply with its obligations. The 2001 draft articles on responsibility of states for internationally wrongful acts, I.L.C., dedicate significant attention to countermeasures, reflecting their centrality in state practice and legal doctrine. Oscar Schachter notes that the inclusion of countermeasures in the draft articles was contentious. Some welcomed codification as necessary, while others worried about unilateral coercion, power imbalances, and resistance to compulsory third-party dispute settlement. The most divisive issue was the idea of countermeasures of general interest, measures that any state could take in response to breaches of erga omnes, or jus cogens obligations, for example genocide or aggression, even if it had not been directly injured. Advocates argued that such measures defended the collective integrity of the international community. Critics, however, feared abuse, since states might mask self-interest as altruistic enforcement. Ultimately, these measures were not included in the final text, though Alland argues that their spirit survives in state practice and jurisprudence. The cornerstone of the draft articles is Article 22, which states that an otherwise wrongful act is not unlawful if it constitutes a countermeasure taken against a wrongdoing state in accordance with the articles. Two conditions follow. The state invoking the countermeasure must have suffered injury, and the measure must be non-forcible. This reflects the long-standing distinction between lawful, non-forcible countermeasures and unlawful armed reprisals. The ILC's commentaries stress that reprisals has fallen out of usage precisely because of its association with force. The International Court of Justice, in Gabcíkovo-Nagymaros project, confirmed that unlawful conduct can be justified if it qualifies as a proportionate countermeasure aimed at inducing the responsible state to cease its wrongful act and provide reparation. Similar reasoning appears in arbitral cases such as Naulilaa, Cysne, and the Air Service Agreement arbitration. These decisions underline the principle that countermeasures must target only the wrongdoing state. Reprisals against third states are impermissible. Cysne established, however, that indirect effects on third states do not invalidate countermeasures, provided no independent obligation to them is breached. Countermeasures are subject to strict requirements designed to prevent escalation and protect fundamental norms. Proportionality. Under draft articles, Article 51, and the Naulilaa incident case, they must be commensurate with the injury suffered. Temporariness or reversibility. Draft article, Article 53, states that measures must be lifted once the wrongful act ceases and are ideally reversible. Respect for fundamental obligations. Under Article 22 of the draft articles, countermeasures cannot undermine jus cogens norms or humanitarian principles. Article 52 imposes certain procedural safeguards. The injured state must notify the wrongdoing state of its grievance, call for cessation or reparation, and indicate its intent to take countermeasures. These steps aim to encourage negotiation and de-escalation. Under Article 52, 3 and 4 of the draft articles, both injured and responsible states are expected to act in good faith. Thus, countermeasures are framed not as punishments, but as regulated inducements to compliance. While the draft articles exclude explicit recognition of collective countermeasures, Article 22 does not categorically forbid them. Case law, most notably dicta from the International Court of Justice, suggests that in cases of breaches of obligations owed erga omnes, all states have a legal interest in compliance. This opens the door, at least in principle, for states not directly injured to adopt limited measures to uphold the collective order, though such practice remains controversial and politically sensitive. In conclusion, countermeasures occupy a unique space in international law. They are unlawful acts rendered temporarily justified as responses to prior illegality. To remain lawful, they must be non-forcible, target only the wrongdoing state, be proportionate, temporary, and reversible, cease once the wrongful act stops, and be undertaken in good faith with due procedural safeguards. Measures intended as coercive reprisals, disproportionate sanctions, or those harming third states are illegal. Though countermeasures of general interest were excluded from the final draft articles, the idea persists that breaches of obligations owed to all states may permit collective responses. Ultimately, countermeasures reflect the tension in international law between unilateral enforcement and the need to maintain order, fairness, and restraint in the decentralized international system. Thank you for your interest in this topic, and we are looking forward to seeing you again soon.